Welcome, everyone. My name is Kerry Stahlin, and I'm a Customer Success Manager here at Sourcemap. And today we're joined by Tim Van Canneyt, who is a partner at Fieldfisher. This session will be about navigating GDPR, and we'll dive right in. Welcome, Tim. Thank you for joining us.
Hi, Kerry, and thank you for inviting me. I'm very pleased to be able to share some thoughts on GDPR and how that impacts supply chain due diligence.
Yeah, we're really excited to hear your insights. So let's dive right in with the most important one. What is GDPR and what does it stand for and what does it entail?
Yeah, so GDPR has become one of those very well-known acronyms in the legal sector. It stands for General Data Protection Regulation, and it's basically an EU law that's, let's say, dictates how organizations may or may not collect, use, and share personal data, something which is close to and similar to what is commonly known as personal identifiable information in the US, but not exactly that. Exactly the same, but so rules on the use of personal data. It's a comprehensive law in the sense that it really applies across all kinds of sectors, which is already also a bit different from the approach that is typically adopted in the US. And on top of imposing all these obligations on organizations, it also grants rights to individuals. Individuals have the right, for instance, to be informed about the fact that their data is being processed. They have the right to rectify the data if it's incorrect or to delete certain data. So it is quite centered around the individuals. As such, GDPR was adopted in 2016, became effective 2018. So in May 2023, it will have been in effect for 5 years. And it has become, I think, one of the really impactful and important laws that the EU has adopted because it really applies across all these kind of sectors. And really applies to organizations across the globe. So it's not just something that is relevant to EU companies, EU-based companies. It has much wider ramifications. And it really should be seen, I think, in light of the fact that the right to data protection as such in the EU is considered a fundamental right. So we have in the EU this Charter of Fundamental Rights, which you can sort of call the Constitution of the European Union, if I want to use a parallel. And within that charter, the right of data protection has the same legal value as other rights that are well known, like the right to freedom of expression. And so because of the importance that is attached to the right to data protection, Europe, the EU, felt that it needed strong rules about data protection and the way in which organizations process data, hence the adoption of the GDPR.
Wonderful. Thank you for that explanation and the history. I think it is something that, we all see in our day-to-day lives now, and it's so important. But there's a lot to learn about GDPR. And one of the things that you mentioned was that personal identifying information. And I think that's a big question for folks. So what types of data count as that personal identifying information under GDPR laws?
Yeah, that is indeed, let's say, the starting point, right? It regulates how you can use personal data, but what exactly is personal data? If we look at the legal definition, it says basically personal data is any information about an individual, so a natural person, that allows it to directly or indirectly identify that person. So it is a very, very broad definition, much broader than the way in which PII is typically defined in the US. Because first of all, if we break it down, it is any kind of information. Could be anything potentially, really. So it's not just my name, my address, but it's also about my preferences. It is about browsing behavior on the web, etc. So it is really very broad. And it relates to any information about natural persons. So it's not, and I think that is really very important to bear in mind, GDPR, it's not about consumer protection. It is about us citizens, humans. So it protects personal data of individuals, both in a private context, but also in a professional context. work-related data about an individual is personal data. So my professional email address at fieldfisher.com, my title as a partner at Fieldfisher, that is personal data. It is generally known to the public. That's not an issue. So it's also not just about data which is secret. Data can be widespread on the internet, for instance, but it can still qualify as personal data. And it means that in the context of GDPR, you then need to comply with the rules. And the last element of the definition is that it is about identified or identifiable individuals. So identified, that's sort of the simple part. Obviously, my name, Tim Van Canneyt, directly identifies me as a person. In combination with my address, that will be the same. But more generally speaking, there's a lot of identifiable information, and that is also covered by the GDPR. So identifiable information is really information where you're not able to identify the person. You don't know their name, you don't know where they live, you don't know what they look like, but you are able to recognize them by other means, for instance, by relying on some kind of identifiers. And to make it a bit more tangible, a typical example is an IP address. If I would now visit your website, just by visiting the website, you will not know that the website visitor is a man called Tim Van Canneyt, based in Belgium. But because of the IP address and some other identifiers that are linked to that, you will be able to recognize that this website visitor is actually the same individual that also visited your website yesterday and the day before, and perhaps even the week before. And so if you combine those indirectly identifying elements of information with my browsing behavior, for instance, the fact that I was always browsing the pages on your website that have articles on sport, or that I was really, if it's an e-commerce website, looking for power tools, etc., then you will be able to create a profile about that individual. And you will not know still that it is Tim Van Canneyt who is behind it, but if you keep on collecting and adding a lot of data to that profile, your profile can actually become very detailed, and you're able to derive a lot of insights on that individual. And so all those indirectly identifying elements of data are also protected by the GDPR. And I think the last point that I would add on personal data is that it's really regardless of nationality. So the GDPR is not just about protecting EU citizens. It is in the EU considered as a fundamental right. So it is a protection that applies to all humans, let's say, around the globe. The trigger for the application of the GDPR is not where is the data subject, the individual located, but where is the organization who is processing personal data located.
I think that segues nicely into how this impacts organizations and what types of companies should be concerned about GDPR, and really who does it apply to. I think you gave us a wonderful perspective from the individual. So would love to hear your thoughts on what types of companies should be looking out for these regulations.
Yeah, so, well, in short, the answer is that every company that has a link with the EU needs to comply with the GDPR when they process personal data. And that link can be really a very light touch link. If an organization, if a company has an establishment, an affiliate that is based in the EU, then there is really no discussion possible. The processing that will be conducted in that context will need to comply with GDPR. But we have case law from the European Court of Justice that has acknowledged that having just only one sales rep being present in an EU member state suffices as having a tangible link with the EU, and that in itself, so only having one person, and that person may just work from home, but having that one sales rep within the EU may already trigger the application of the GDPR. So that is a very broad scope, but it even doesn't end there, because even organizations which don't have any such physical presence in the EU, if they are based outside of the EU, but they target individuals in the EU, or they offer goods or products for sale to individuals in the EU, even then based on the extraterritorial scope of the GDPR, they will need to comply with the rules. So in short, it really applies to a whole host of companies, certainly in this globalized world. There are a lot of companies, even those who are not in the EU, that need to comply with the GDPR. And again, as I mentioned, it's not just it's a comprehensive law. It's not sector specific. And I'm really emphasizing this because it's very different from the, let's say, typical US approach to data privacy. It doesn't matter if you are a B2C or a B2B company, if you are a public authority, if you are an NGO, every organization that processes personal data and that has this link with the EU needs to comply with the rules. So yeah, it applies much quicker than you could imagine potentially if you're not in the EU.
Yes, certainly you illustrated the very broad applications of this regulation. It's not just those folks in the EU who have to think about this. It's global. And would be curious to hear your thoughts on some of the top challenges that brands or companies face when they are attempting to comply with these GDPR requirements.
Yeah, so I think before diving into that question, I think that there are two key concepts that I should briefly mention, and I'll try not to make it too technical. But the GDPR has sort of two main actors that the rules apply to. On the one hand, you have the entity that is considered to be the data controller, and on the other hand, you have the entity that is considered to be the data processor. And the GDPR obligations are a bit different depending on which hat a company is wearing. So it's always very important, once you've sort of established that the GDPR applies, that you also decide or determine which hat you are wearing, whether in relation to processing activity, whether you are the controller or the processor. What is the main distinction? Well, the controller is basically the entity that determines the purpose and the means of the processing. So it's the answer to the question, who decided why and how personal data will be processed. And if we look at supply chain due diligence, obviously it will be the brand who wants to know the end-to-end supply chain. They will want to collect certain personal data. And so I would say in 99%, if not more of the cases, they will act as the data controller. But the reality, and again, in this globalized world, is that controllers often are not able to do the entire job alone. They rely on service providers who are able to deliver specific tailor-made services. They will rely on a lot of IT systems. They will have certain data which are cloud-based, hosting providers, etc. So there are a lot of service providers that will somehow help them achieve their objective. And those service providers typically will qualify as the data processor. So it is an entity who will have some interaction with the data with the data that's being processed, and that could be the fact that they are collecting personal data, but it could be limited to the mere fact that they're actually hosting the data. So AWS is always or is typically the data processor of any organization that uses AWS to host their systems and the data that is on it. So those organizations, they provide a service, but in relation to the personal data, they act on behalf and on the instructions of the controller. And that is really key. They are only allowed to do certain things with the personal data within the mandate that they have received from the controller. And so the controller in this whole situation has the overall end responsibility of complying with the GDPR, must comply with most of the legal obligations, whereas the processor has slightly less legal obligations directly under GDPR, but it will have to comply with a set of contractual obligations that are imposed by the data controller in the context of what is commonly known as a DPA, a data processing agreement. And so to give a practical example, data breach notification obligations, which are well known in the US as well. Under GDPR, actually the data processor only has the obligation to notify its data controller, A processor never has to notify any authority or any data subjects. It is only, as per the GDPR, the controller who needs to notify the data protection authorities and or the individuals if the thresholds are met. So that is really one first very important distinction that any organization should make. If we then look at what's sort of the key challenges are, coming back to your question, it is quite a difficult task, and I think my key message is always that it's not a project that you can do from today and which will end end of the month or end of this year. It is really, well, it's about compliance, and as you know, that is sort of an ongoing obligation, right? There are a couple of key obligations that any organization must really bear in mind whenever they process personal data, and they are considered to be the sort of key data protection principles. Transparency is really one of the key obligations, and this goes back to data protection being a fundamental right. Individuals are supposed to know and have the right to know actually who you are, why you have their data, and what you will do with that data. And so this is all about this obligation to provide and make available a privacy notice to individuals. That is one of the, I would say, most fundamental obligations for any organization, and which will be relevant, obviously, in this particular context of due diligence. Another key obligation is purpose limitation. You should not use data that you've collected for a specific purpose for other purposes just because you can. You really need to identify upfront why, for what purpose am I collecting data? And so here, obviously, the context would be we want to comply with specific regulations around supply chain accountability. In that context, we've determined that we need certain data and we will use it for that. Once you have it, although it may be tempting, you're not supposed to say, oh, well, actually we can monetize this and we will sell it or we will use it for direct marketing purposes. Those are other purposes and that would not be compatible. Data minimization, also a key one. You should only collect as much data as you need to achieve your objective, your purpose. So again, if you want to do your due diligence, you need all the information you need in terms of who are the directors of certain organizations, who are the shareholders, etc. You probably will not be able to justify that you need to collect any data about, let's say, sexual orientation of those directors. That is irrelevant in the context of your purpose. And so that would be unlawful. So only collect the data that you really need, and also only keep the data as long as you need it. That's also, and I think in practice, one of the most difficult obligations to comply with. Data storage, the price of storing data has really reduced a lot, and with cloud computing, it's so easy to just keep on adding data to your databases. But from a compliance perspective, under GDPR, it is an issue because the principle is that you shouldn't keep data longer than necessary to achieve the purpose. And so that is a very unclear and open-ended obligation. The GDPR doesn't prescribe that you should delete data after 5 years or after 10 years or after 1 month. It doesn't give any specific indication of data retention periods. You have to decide that yourself, and it will depend on the context. So for instance, here, I would imagine an organization will be able to justify that you keep the data for as long as you are under this legal obligation, or for as long as you are collaborating with certain people in the chain, in your supply chain, because you need to be able to provide the evidence to authorities who may start an investigation. But that means that for company A, they may justify that their data retention will be 5 years, and others will say we will keep it for 10 years because of these reasons. So that will really depend, and so that is an exercise that you have to do yourself. Which links to one other very key obligation, which is the accountability obligation. the law contains, the GDPR contains very general principles like the ones that I've explained, and it is up to every individual organization to sort of get to grips in terms of what it means for them. And so you need to comply with these rules, but you also need to be able to demonstrate that you comply with these rules. And that is sort of this abstract concept of accountability. It means a couple of things. It means that you unfortunately need to document quite a lot of things. There is a requirement to have so-called records of processing, so sort of an internal inventory of all your processing activities. What are the purposes? Which kind of data do we collect in that context? Who do we share it with, etc. So it's a bit of a data mapping, let's say, if I sort of present it in a simplified way. In certain instances, before you start processing data, you need to do what is called a data protection impact assessment, which is basically a risk analysis of your processing activity, but not looking at a risk for your organization, which is what a risk assessment is typically about in a corporate world. Here, the risk assessment is about the risk for the individuals whose data you will process. So if you start processing data about shareholders, directors, or farmers, which measures should you take to make sure that their right to data protection will be complied with? And then other accountability obligations. Sometimes an organization needs to appoint a data protection officer. I already mentioned the data breach reporting requirement. So there is actually, and perhaps unfortunately, really a lot to take into consideration. And all this makes it very hard to really be compliant with these rules, unfortunately.
It sounds like there's a tremendous amount of work that goes into following these regulations on both a controller and a processor standpoint. I guess what happens when a brand or even a processor is found non-compliant? What happens on the flip side?
Yeah, so I perhaps as a side note, it's my personal belief that full compliance with the GDPR is an illusion, and I think I'm weary of any organization who claims or pretends to be GDPR compliant. I don't think that is possible because of the scope of these obligations. What obviously matters is that within the organization you try to implement appropriate policies, procedures, that you raise awareness, training of individuals, of staff, so that you're able to achieve a decent or very decent level of compliance. And it is a lot of hard work, but it's not something that should put people off either. I mean, I won't sort of underestimate the work that is involved in making sure that you try to comply as much as you can, but it's not a hurdle to doing business, and I think that is really an important point. I've often seen that GDPR is used by scaremongers to sort of really scare people. I've rarely come across situations where operational people, business people, need to stop doing what they're used to doing because of GDPR. Typically, they just need to tweak things, but it's hardly ever a real barrier to conducting business. But all that means that sooner or later, an organization may find itself in a situation of non-compliance. The main risk of not complying is basically fines. And it's really, I would say, one of the key changes that we have with GDPR compared to the previous regime, because data protection rules in Europe, they have been existing since 1995. It's just that before GDPR, a lot of organizations sort of took a whatever approach because there was virtually no enforcement. And so one of the key changes the European Commission wanted to bring about with the GDPR was have data protection authorities who would no longer, in their words, be toothless tigers, but would have real sanctioning power. And so data protection authorities, and so every member state in the EU, so the 27 member states have a data protection authority. They are able to impose, to take measures. They can prohibit certain processing activities. They can force you to delete certain data if they consider that data to be unlawful. For instance, the example where you would have processed the sexual orientation of a shareholder, they can say, well, that's not needed, delete it. But most importantly, I guess, is obviously the administrative fines, which, as most people probably will have heard of, can go up to 4% of the global annual turnover of an undertaking. So that's really at a consolidated basis. Or if it is less, then it can go up all the way to 20 million euros. So it depends whichever is the higher. And that has been a real change, because before in many organizations, in many member states, there were either no possibility to impose fines, or they were quite limited to a few thousand or hundreds of thousands euros. So that has been a real change, I would say. In addition to that, some organizations, some are potentially also facing criminal fines. There are certain member states who adopted, in addition to the administrative fines, criminal sanctions, either on the organization or potentially also on the directors. So that is obviously also something to bear in mind.
Thanks for walking through that. And I think it's important that you noted, there's a lot of regulation to follow, but it's not to deter anyone from going forth and doing all that they can to complete the journey towards compliance. So here at Sourcemap, obviously, we're very closely integrated with supply chain, and a lot of the folks on the line are as well. So curious to hear your thoughts on how the GDPR regulations impact the data collection process for supply chain due diligence.
Yeah, well, sorry, I think there as well, it's a good example of the fact that GDPR is not a barrier. It will not make it impossible to conduct, and it does not make it impossible to conduct supply chain due diligence. It just requires potentially some tweaking in the way in which organizations are or have been conducting those exercises in the past. And it really goes back to these fundamental principles that I mentioned. It's important to sort of assess or reassess whether you are collecting perhaps more data than you strictly need to achieve your objective of supply chain due diligence. I think probably one of the key points where I would expect that there might be issues around compliance is around transparency. Obviously most of the data that will be collected in the context of such due diligence is sort of company information or financial information, but there will be sort of perhaps in the sort of orbit around that, there will be personal data, whether it is the information about shareholders, etc., that I mentioned. Those people under GDPR should be informed of the fact that company A is conducting this due diligence, and so they should get access to a privacy notice. In the past, sort of the general approach to that was just publishing a privacy notice on the website, and that was then supposed to be a public communication to the entire world, and people were able or were supposed to be informed. But obviously, if a director of a company, I don't know, based somewhere in Latin America or in an African country, doesn't even know the existence of the organization that mandated the due diligence, and how would they even know about their existence, and how would they then go on that website to find out more about why they are collecting their data and what they are doing with that data. So we have now several decisions that have been adopted by data protection authorities who clearly say it's insufficient. It's still good practice to publish your privacy notice on the website, but you need to take sort of an active step. You need to really make that information available, which means that if you think of sort of the service providers that may be involved in this chain, that you may actually in your contract as a brand, you may want to consider imposing an obligation to to the service providers that they actually give a copy, make available a copy whenever they conduct interviews with people, if that would happen. If the data is pulled from public sources, which will obviously also happen if you are trying to identify directors in an organization, even then actually you have an obligation to still in parallel send them an email saying, okay, we are brand X, we have conducted the supply chain due diligence, and just for your information, this is what we do with the data. You don't need to actually give them a copy of all the data that you collected. You just need to sort of in general broad terms explain what are the sort of categories of data that you collect and the purpose for which you are collecting that. So that is, I think, really one of the, let's say, key challenges in my view. I think also, obviously, then going back to the storage limitation, how long do you keep the results? That is a difficult one. There's no easy answer to that, I'm afraid. As a rule of thumb, what we often see in similar situations is that organizations really look sort of at the statute of limitations. If there are laws that oblige me to conduct these kind of due diligence exercises, well, for how long can I be held accountable by national authorities? How long would it be needed for me to defend myself as an organization and be able to provide evidence that we did what was required? And that quite often then sort of dictates the data retention period. But one other consideration that I haven't mentioned, which I think can be very useful in this particular context, is the question whether it's really needed to keep the data personal. Is it possible to de-identify, to anonymize the data? Obviously, during the time frame that you conduct the due diligence, then obviously you will collect personal data and you will need it. But perhaps once it's completed and you've created the report, one might question whether you still need the sort of underlying raw data. And perhaps there is a good reason why you should keep it, and then there is no issue. But if you no longer need the raw data, then it may be an issue to either anonymize it or pseudonymize it, which is a way of protecting it as well. So you remove the direct identifiers, you remove the names of the individuals, and you put an alias like farmer XYZ, so that the raw data, if someone gets access to that or that raw data sheet is breached, you're not able to identify the individuals, but obviously somewhere else in the organization, someone has in a secure way stored sort of the key, which says, well, farmer XYZ is Tim Van Canneyt, for instance. So these are, I would say, are some of the key elements that I think I would recommend looking into.
Wonderful. Lots to think about I think for everyone, especially on this call. And I'm wondering if we can walk through a specific use case that is near and dear to Sourcemap and our customers. So let's say that a company is mapping their supply chain and needs to collect data on a smallholder farmer. Even though that data is business information about that farmer, it may match with their personal identifying information. So what happens then?
Yeah, so well, in essence, I think there's a couple of questions that need answering that the company should ask. I think really the obviously first question is, does the GDPR apply? Am I as a company subject to the GDPR? And so this goes back to the question, do I have some sort of an establishment in the EU? Or if I don't, do I offer goods and or services to individuals based in the EU? In many cases, if we're talking about sort of global brands that operate on a global level, the answer will be yes. So if you've determined that you are subject to the GDPR, I think then the second question is, are we processing personal data? Because if we're not processing personal data, even if we're technically, theoretically subject to the scope, there's no issue at all. And I think in the example that you mentioned, I think it's an interesting one, because obviously the whole idea behind this is to really establish the end-to-end supply chain. And as I mentioned, most of the data will be business information. It's data about companies, but it will necessarily involve within that chain certain elements of personal data. And I think specifically speaking about someone like a smallholder farmer, the data that you may collect, it may all be company information. So the sort of seeds of that smallholder farmer's business, what's the address of that, what are the identifying, what is the registration number, etc. But what we will see in practice is that actually that address is likely going to be the same of the individual that is running the business, the actual farmer, and so there is an overlap between that person's domicile, let's say, and the official address of his business, and so even in those cases, it is considered to be personal data. There is actually even now sort of, and there has been quite a bit of debate. What we often see with management companies, for instance, a lot of consultants, when they adopt a management, when they create a management company, they don't come with an invented name. They just call it, or they include their own personal name, and so it could be something along the lines of Tim Van Canneyt Consulting Inc. or Limited. And previously, it was people were saying, well, yeah, no, this is a corporation, so GDPR doesn't apply. It's not data about a natural person. The way in which the regulators and case law is now interpreting this is, well, no, it still refers to the person behind that corporation, and so even that is personal data. So all that to say that if you, in the context of the mapping, conclude that the GDPR applies, you might almost as well skip to question 2: do we process personal data? Because to me, it seems very unlikely that there would not be any personal data involved in the mapping as such. So then the third question is, yeah, well, which hat am I wearing? Am I the data controller or am I the data processor? And again, that distinction is important because it sort of drives the exact obligations that you need to comply with. Here in the example that you gave, if it is really the brand who ordered the mapping to be conducted, there is little doubt that the brand will qualify as the data controller. If it then relies on service providers, those service providers could either be a data processor or a data controller. They will be data processor if they really act just based on the mandate and they do the research and then hand over all the data to the brand, and at the end of the mission are under the obligation to delete all the data. And then they really wear the hat of a data processor. If on the other hand, that service provider has sort of compiled a historic database of all kinds of organizations and actually has a lot of data itself, and so whenever it gets a request to do a mapping, it actually has data and it keeps that data at the end of the mission, well, then actually that organization, that service provider, despite being a service provider, will qualify also as a data controller. And so will then also need to comply with a whole set of legal obligations. But so that determination is really key, because once you know then which hat you are wearing, you can really sort of go through your checklist of all the legal obligations that need to be complied with that specific role.
Thank you for walking us through that. It sounds like it's really important to recognize your role too as the controller or the processor when that changes, to understand how to comply. I know we have about 15 minutes left, so I will ask one more question, then we'll open it up for Q&A. So looking ahead, how do you think that privacy laws like this might continue to evolve? Very curious on your thoughts here.
that is it's a tough question. I obviously don't have a crystal ball, but I think if I look at trends, actually there are two trends that I'm seeing. One is sort of outside of the EU and one is within the EU, and it's quite different because the trends are quite different. So it's interesting. I think looking outside of the EU, what we are seeing is that the GDPR has really become sort of the reference act for data protection around the globe. And we're really seeing more and more countries across the globe who are adopting data protection laws, national data protection laws, which are very similar, sometimes even almost copy-paste versions of the GDPR. That is happening in Latin America, in Asia, but I mean, even in the US, currently, obviously, there's already a lot of state laws, but there's currently a draft federal data privacy law that is being discussed in Congress. So the GDPR has really set an example, and I think in terms of how the world is evolving, I think we will see more and more of GDPR-like laws in all kinds of different countries. If we then look at the EU perspective, it's a different trend, and it may sound as a surprise, because in a way you could say, yeah, the GDPR has been a huge success because it has really become an example for other countries. And I think that is in part true, but there is also a lot of criticism in the EU. There is at the moment a quite vivid debate that is ongoing within the EU whether the GDPR has really achieved its objective. And as I said, one of the objectives was reinforcing the rights of individuals by reinforcing or by enforcing the law, actually. And there is a lot of debate and complaints about the fact that despite those new powers that those data protection authorities have obtained, that there is still insufficient enforcement, and that too many companies are still failing to comply with GDPR, and that data subjects don't get the protection that they should get. And that is an interesting debate. There's a lot of politics behind it, of course. It's in part an issue of resources. A lot of the data protection authorities didn't receive the funds they needed from their member states to really cope with the increased workload that they have. I think a notable example is the Irish DPC, who is the competent regulator to enforce the GDPR on many of the big US tech companies who have their main establishments in Ireland, in Dublin. The DPC, although they have sort of doubled or tripled in size, they are just not able, their caseload is so high that they're unable to process all those cases. So there is a huge debate on what should we do next? Should we sort of centralize enforcement? Should the European Commission become competent to enforce GDPR in sort of cross-jurisdiction, cross-border cases, like it is the case with competition law? So that is an ongoing debate. I'm expecting that we will see indeed an increase of the enforcement somehow. It will take some time, but at some point, member states will have no other choice than to give additional resources to the regulators, and then they will have more powers, or they will be able to actually use those powers that they have.
I think we all wish we had a crystal ball to see exactly what would happen in the future, but really appreciate your informed insights here. I think there's a lot that we all could look to. So we have about 10 minutes left and a couple questions from the folks on the line. So the first one being, could you explain the distinction between anonymization and pseudonymization regarding GDPR?
Yeah, happy to do that. It's a very good question, because as I mentioned, the GDPR applies to processing of personal data. The sort of opposite of personal data is anonymous data. When you process anonymous data in the sense of the GDPR, you can forget about GDPR. GDPR doesn't apply. Somewhere between personal data and anonymous data, you find pseudonymous data. And pseudonymous data is subject to the GDPR. It is considered to be a subset of personal data. So what is the distinction? Anonymous data is data where it has become permanently impossible to re-identify the individual. So you've removed all the elements that allow you to identify the individual, in a permanent way. So you didn't keep a separate key where you still are able to re-identify. You removed that, but you also added what people often call salt in the context of hashing. You added elements to sort of make it, well, to really de-identify the person. So instead of saying we are talking about a lawyer based in Brussels who is male and who is age 41, you will say it's a lawyer based in the EU, age between 40 and 50. That makes it much less easy to identify, because what studies have shown is that you only need a few data elements to, with the internet and with technology, to find other elements, bits and pieces, crumbs everywhere online, to still be able to re-identify. So actual anonymization of data is incredibly hard. And in reality, what you will see is that most often you are not dealing with anonymous data, but with pseudonymized data. So where some elements have been removed, but it's insufficient. So it still allows you to recreate that link with the individual. And in that case, actually, there is no distinction between pseudonymous data and personal data. All the rules that apply in the GDPR to personal data equally apply to pseudonymous data. As I said, it's really only just a subset. It is still a good idea to pseudonymize data because you sort of reduce the risk. If your pseudonymized data is lost and or breached or hacked or whatever, and the people weren't able to sort of also get access to that separate sheet that you have with the key codes, well, then obviously the use, what they can do, the harm for the individuals will be much lower. So if you have a data breach and the data that was breached was pseudonymized data, the regulator will still consider this to be personal data, but they might potentially even give you a pat on the back saying, well, actually, it's good that you've pseudonymized it because in this specific situation, there was no harm for the individuals.
Well, thank you. We'll need to capture those definitions somewhere. That was really helpful. We had a second question, and that is, to what degree do data ethics principles outside of formal regulations intersect with the GDPR?
So yeah, that is, I mean, there is the debate on data ethics is not a new debate, but is a debate that has really sort of come to the center stage in the past couple of years, let's say. It is an important debate, but if we really look just at GDPR compliance, it is not really something that is directly part of the rules. You might argue that if you think of data ethics principles, it will sort of also help you to comply with those fundamental principles that I mentioned, like storage limitation, or the fact that you don't use data for other purposes, or that you don't collect more data. You can say, well, we consider it's ethical to only collect those elements that we need. So in that way, there is a bit of sort of well, not necessarily an overlap, but they sort of influence each other. But if you really look at it just from a pure compliance with the law perspective, data ethics as such is not enshrined in the GDPR.
Wonderful. Thank you for going through that. I know data ethics is such an important conversation and topic. I think we have another question here, and this dives a little bit more into the details of GDPR. What does data protection by design and by default mean? Yeah,
good. So those are two principles that are linked to the accountability principle that I mentioned. If I simplify it, it basically means that before you start a processing activity, or before you develop a new tool that will process personal data, that you ask yourself the question, how can we do this in the most privacy-friendly way for the individuals? It's almost as simple as that. That's really the question. So it is the exercise of not just looking at what is the business interest of doing this, but also which measures should we take to protect the data. And the reason why those two principles have been enshrined in GDPR is that it is really something that you should be doing from the outset, especially if you develop new systems or tools, because if you first develop something and then once it's ready, you start thinking about it and you try to add some sort of additional layers, it really generally doesn't work. So a lot of the functionality, for instance, data protection by default, if we think, what would it be, 10 or 15 years ago, the very early days of Facebook, those people who had their profile, the profile page by default was public. Everyone could get access to it. And so everything that you would post was by default accessible to the whole world, and you were able to sort of restrict access to only your friends or to only those people that you knew. Data protection by default actually means exactly the opposite. So if you have the choice between different settings, by default, you should choose the most privacy friendly, the most restrictive setting from a data protection point of view. So it really links to this data protection impact assessment that I mentioned as well. When you conduct this risk assessment at the beginning of your project, it's those, well, it will essentially be among those two principles that you will look into, and obviously data security will play an important part in the analysis as well. But you really will look at how should we design this activity, this process, or this tool or system in a way that we are able to meet our obligations under GDPR and that we're able to protect the data of individuals.
Thank you. And I think we have time for just one final question. So curious about what happens if a company faces a security breach and what level of liability they would face there.
What happens if an organization suffers a security breach? In my experience, it typically happens on a Friday afternoon around 5 p.m. and there is distress all over the place. But from a legal perspective, I think there's two important things that should be distinguished. There is an obligation to notify. Well, first of all, not every security incident will be a personal data breach under the GDPR. There is an obligation to notify personal data breaches, but if your security event doesn't involve any personal data, no reporting obligations whatsoever. So that is always the first assessment to make. We've had an incident, but did it affect any personal data? If you see that it does affect personal data, then in most cases, or let's say by default, you will have to notify your data protection authority. With regard to the individuals, by default, you don't need to notify them, and that's and in the US that's well known as well. It's to avoid notification fatigue. So you only need to notify the individuals if there would be a high risk to them, their credit card details are compromised, or other elements that might really affect them in a quite substantial manner. So that is a legal obligation. If you are legally required to notify the breach and you don't, you're not complying with the law and you could be fined. However, and that is something that people sometimes forget or overlook, it's not because you suffered a data breach that the existence of the data breach as such signifies that you didn't comply with the law. Because in terms of data security, the GDPR doesn't require sort of absolute Fort Knox security that is impenetrable. No, it says that you need to implement something which is called appropriate safeguards, technical and organizational. And appropriate, well, what is appropriate? It depends really. It depends on the type of data that you're processing. So if it's just email addresses, the measures that you take will be different than if it is a hospital that is collecting health data, or if it's a bank that is collecting and processing credit card information. So it depends on the context, but you can also look at the cost. You can actually factor the cost of implementing the best possible security into your assessment, whether it is appropriate or not to do it. And so the regulator will, when there is a personal data breach, the regulator will check, did you implement those appropriate safeguards? And the answer may very well be, yes, you did implement that. And despite that, well, you were unlucky, there was a data breach. that's okay. You notify the data breach, and so actually you complied with all your obligations, and there is no reason whatsoever to impose a sanction. If you did not implement appropriate safeguards, or you fail to notify it, well, then obviously it's a different story. Then you might be sanctioned and a fine could be imposed.
Thank you so much for walking us through that. And thank you for sharing your knowledge and insights around GDPR. It was very, very excellent.